All right, let's jump right in. Today, we're going to pull back the curtain on a legal strategy that most people never even hear about. It's a defendant's playbook for shutting down a lawsuit before it ever really gets off the ground.
I mean, think about that. What if you could win before the fight even started? It sounds a little like a fantasy, right? But it's not. It's a very real set of strategic moves that are available from day one. So, how in the world does this actually work?
Well, it all starts right here. That moment, someone hands you a pile of papers. You've just been served with a complaint and a court summons. And in that instant, a clock starts ticking. The pressure is officially on.
Now pay close attention to that word, commands. A court summons is not a friendly suggestion. It's not an invitation. It is a direct order from a judge. If you ignore it, you will likely lose the case automatically. So doing nothing is absolutely not an option.
The stakes are immediately high, and you know you have to do something. But the single most important decision you have to make is how you're going to respond. That very first move you make can define the entire game.
And this is where you hit that first critical fork in the road. Are you going to go down the standard path and just file an answer? Or are you going to take a more aggressive route and attack the lawsuit itself?
This really lays out the two choices perfectly. The standard path is filing what's called an answer. You basically go through their claims point by point and respond. You're reacting. You're agreeing to step into their arena and play by their rules. But then there's the strategic path. This is proactive. Instead of just answering the claims, you challenge the very legitimacy of the lawsuit, trying to knock it out before it goes any further.
And that proactive strategy is often called the flurry of motions. You can think of it like a team's opening playbook, a series of moves designed to completely dismantle the other side's case before they can build any momentum.
This playbook really boils down to three core moves: the motion to strike, the motion to dismiss, and one called a motion for a more definite statement. Let's break down what each of these actually does.
So, first up is the motion to strike. And just listen to the kind of stuff it's designed to attack. We're talking about allegations that are scandalous, insolent, or utterly false. This isn't for a simple disagreement. This is for things that are completely out of line. Essentially, with this motion, you're going to the judge and saying, "Your Honor, look at this. This part of the complaint is just plain false, or it's irrelevant, or it's just designed to make me look bad. It has no place in a court of law." It's a way to clean things up and, maybe more importantly, show the judge right away that your opponent might be playing dirty.
Now, there's an even more powerful version called a motion to strike sham, and this one is a huge deal. Here, you're not just saying the other side is wrong, you're accusing them of putting things in a court document that they knew were false. That's an incredibly serious charge. Lying in a legal pleading can lead to contempt of court, big fines, even jail time. This can be an absolute knockout punch.
Okay, next in the playbook is probably the one you've actually heard of, the motion to dismiss.
What's interesting here is that this motion doesn't really argue about who's right or wrong on the facts. Instead, it argues that the entire lawsuit has a fundamental legal or procedural flaw. Maybe they sued you in the wrong state, so the court has no power, no jurisdiction. Or maybe, even if everything they said was true, it just doesn't add up to a real legal claim. If the judge agrees with any of these points, poof, the case is gone.
All right, our final motion is one that, believe it or not, can sometimes be kind of fun. I know, fun and legal motion don't usually go together in the same sentence, right? But check this out.
So take a look at this. This is a real example from a legal document. It says, "The defendant's oncoming automobile at the intersection of 4th Street and Maple Avenue," and then nothing. It just stops. It's not a sentence. It's a fragment that doesn't actually say anything.
I mean, what are you even supposed to do with that? How can you admit or deny it in a legal document? You can't. It's just gibberish.
And that is exactly where this motion comes in. It's your formal way of going to the court and saying, "Your Honor, I literally have no idea what they're trying to accuse me of here. It is so confusing, I can't possibly form a real response." And if the judge agrees, they can order the other side to go back and rewrite their complaint so it actually makes sense.
So, okay, we've gone through the what, the three main plays in the book. But now let's talk about the most important part, the why. What is the real, tangible payoff for using this strategy?
The payoff is all about avoiding this. Because let's be honest, lawsuits can turn into absolute nightmares. They can become these long, complex, drawn-out fights that drain your bank account, your time, and frankly, your health. The stress is enormous. This strategy is designed to let you sidestep that entire miserable journey.
Because the whole point of this playbook is to replace that long, costly path with just one thing:
a win. The goal is to end the lawsuit right then and there. No depositions, no endless back and forth, no trial. Just a swift, decisive victory.
So, when you boil it all down, what's the big idea we should really take away from exploring this defendant's playbook?
I think it's this. This strategy is about so much more than just playing defense. It's about flipping the script. Instead of just reacting to what you're being accused of, you are immediately attacking the validity, the clarity, and the legality of the lawsuit itself. You are seizing control of the narrative from the very first move.
And it leaves you with a really fascinating thought. You know, maybe in the world of law, that old saying gets a little twist. Maybe the best defense isn't a good defense at all, but a swift, strategic, and powerful first offense.